Gerrymandering, dealing with campaign finance, dealing with a challenge, an as-applied challenge to the McCain-Feingold law. As Professor Garrett, Provost Garrett, takes the podium, we will hear from the Chief Justice of the United States.
And the question is whether or not there was a similar history of discrimination that supported extending the effects test in Section 2. It was the position of the administration for which I worked that the proposal was to extend the Voting Rights Act without change. Your position at the time was that the intent test that the Supreme Court had determined was in Section 2 should be changed to the effects test, and that was the position that eventually prevailed. There was no disagreement.
Roberts, the effects test was the law of the land, from the Zimmer case to the Mobile case. It was the law of the land. That was the law of the land that court after court decided about the impact of the effects test. The Mobile case changed the Zimmer case.
Well, Senator, you disagree.
What we were
Senator, let him finish his answer.
Okay. Well, I'd just like to get whether the Zimmer case was not the holding and the rule of the law of the land prior to the Mobile case.
Well, this is the same debate that took place 23 years ago on this very same issue. And the administration's position, you think the Supreme Court got it wrong in Mobile against Bolden.
No, that's not what I think it was wrong, but I also think the law of the land decided by the Supreme Court in the Zimmer case, upheld in court after court after court after court, was the effects test.
Well, and the Supreme Court...
That's all.
Let him finish his answer, Senator Kennedy.
The point is, and again, this is revisiting a debate that took place 23 years ago.
Well, I'm interested today in your view. Do you support the law that Ronald Reagan signed into law and that was co-sponsored overwhelmingly?
Certainly. And the only point I would make, this was the same disagreement and the same debate that took place then over whether the court was right or wrong in Mobile versus Bolden. And the point I would make is twofold. That those like President Reagan, like Attorney General Smith, who were advocating an extension of the Voting Rights Act without change, were as fully committed to protecting the right to vote as anyone.
Right.
Now let him finish his answer, Senator Kennedy.
And the articulation of views that you read from represented my effort to articulate the views of the administration and the position of the administration for which I worked 23 years ago.
Well, after President Reagan signed it into law, did you agree with that position of the administration?
I certainly agree that the Voting Rights Act should be extended. I certainly agreed that the effects test in Section 5 should be extended. We had argued that the intent test that the Supreme Court recognized in Mobile against Bolden, I know you think it was wrong, but that was the Supreme Court's interpretation, should have been extended. Again, as you said, the compromise that you and Senator Dole worked out was enacted into law and signed into law by President Reagan, and the Voting Rights Act has continued to be an important legislative tool to ensure that most precious of rights, which is preservative of all other rights. There was never any dispute about that basic proposition.
Provost Garrett.
Thank you. I want to thank Doug and Dean Starr and the Pepperdine Law School for this opportunity to talk about a set of cases from last term on a topic I call law and politics. And just as politics is messy, so are these cases. This is one area where, if Justice Roberts is really serious about wanting unity, speaking softly and unanimously, and I'm not sure if I take that seriously, he did not succeed here. In two of the major cases, there were three cases, but two major ones, we have 12 opinions, 6 each, and virtually no majority opinion, only parts of an opinion in the redistricting case. So what I want to do is first talk a little bit about the campaign finance cases and then conclude talking about the redistricting case and spending most of my time on the partisan redistricting aspect of that, but hopefully have time for a couple of observations on the voting rights aspects. So with respect to campaign finance cases, we had two cases, Wisconsin Right to Life versus the FEC, and Randall versus Sorrell, the more important of the cases dealing with a law out of Vermont. There were two unsurprising results from these two cases. The first is that as applied challenges to the Bipartisan Campaign Reform Act, BICRA, will be allowed. This is unsurprising. I think McConnell and Buckley before it had made clear that they were facial challenges and had actually contemplated as applied challenges. So I don't think this was noteworthy. This was one of the unanimous ones. It's one of the short ones. The second unsurprising result is that, at least to me, is that expenditure limits in campaign finance laws are unconstitutional. This was a clear holding of Buckley. It was not at issue in McConnell, but I had never expected that the expenditure limit ruling in Buckley would be revisited. Now, I was not, there were others in my field who study law and politics who did think that the court might be willing to look again at its holding in Buckley, that one could not place expenditure limits on campaigns, and there were a couple of reasons for this. Some believed that the decade of experience with campaign finance laws after Buckley could surely convince any rational person that what the Buckley framework was not a workable one. The Buckley framework, which said that expenditure limits are unconstitutional and would be looked at with very strict scrutiny, but contribution limits are often constitutional and would receive a lesser degree of scrutiny, has resulted in a system where the demand for campaign money is unlimited, but the supply is limited. And what you get in such a market, not surprisingly, are diversions to try to get the supply of money that you need for your unregulated demand. The idea was, well, you know, surely after all this experience with Buckley, Buckley came right as we passed the federal election campaign laws. We didn't know what a disaster it was going to be. Surely they'll be willing to look at it again and change their decision. Didn't happen. The second reason some thought that the court might be willing to think again about expenditure limits is that there's at least a strand in some of the newer cases that the holding in Buckley, which said that political equality and the need to try to institutionalize political equality was not a compelling state interest, right? Expenditure limits were dubious, unconstitutional, because they tried to silence some to bring in equality into the system where those with lots of money can speak very loudly. There seems to be a strand, people hoped, where the court might be willing to think about political equality issues, and it was raised in the Vermont case because it had been discussed in some of the opinions below, the need to really think about political equality. Justice Breyer's book, Active Liberty, and some of his other opinions talk about the need to encourage participatory democracy. Maybe that's another way to talk about political equality. And the McConnell court's acceptance of an earlier case, Austin versus Michigan Chamber of Commerce, seemed to be perhaps moving forward toward an equality rationale. In Austin versus Michigan Chamber of Commerce, the corruption the court talked about was the corrosive influence of vast political war chests. And that sounded more like an equality argument. Well, the bottom line in the Vermont case is that the court was not willing to revisit the issue of expenditure limits. And indeed, if the Buckley framework is going to be overruled, it would be my prediction that it will be overruled in the other direction. That is, I do not see a 5-person majority willing to overrule Buckley and to apply lesser scrutiny to expenditure limits. What I do think we might see happen is a 5-court majority want to apply the same strict scrutiny to contribution limitations. You already see that in some of the opinions. Thomas and Scalia have said it explicitly and did so again here. Kennedy has, I think, said it pretty explicitly, does so again here. Justice Alito writes separately in the Vermont case, and says it was not necessary for us to decide whether to overrule Buckley. And my guess is he's not overruling it to let more restrictions stand, but rather to say more are unconstitutional. And we don't know what Roberts is going to do. He didn't join Alito's opinion. He did join Breyer's opinion, which included some discussion of the need for stare decisis in this area and to keep Buckley. But my guess is that if the case comes before the court to squarely revisit Buckley, the Buckley framework may be in trouble, and be in trouble in a way that will cause more campaign finance restrictions to be found unconstitutional. So what was the surprising holding in the Vermont case? I think the surprising holding, at least to me, was that the contribution limits in the Vermont statute were struck down as unconstitutional. This was surprising because the trend in the cases had been to give great deference to legislatures with respect to where to set contribution limitations. The standard of scrutiny is less than for expenditure limitations. And in a 2000 case, Nixon versus Shrink Missouri Government PAC, the court had accepted relatively low campaign limits, about $1,000 for statewide offices indexed for inflation. Now, granted, the Vermont limits were much lower. $400 for individual contributions for statewide elections over the course of a 2-year period, and the same limitations on political parties as on individuals. But my view after Shrink Missouri Government PAC was there would be no limit too low that a legislature had decided to put into place, and the ruling in Vermont shows me wrong, right? There are limits that are too low. These limits are too low. What larger kinds of conclusions can we draw from the Vermont versus Sorrell case? I think there are at least 3. There may be more that come up in the questions and answers. One is, I think we see in the Vermont case the increasingly sophisticated use of empirical evidence and law and social science evidence by courts. Lots of expert testimony, lots of amicus briefs, lots of discussion of the social science studies in this area. In Buckley, no discussion of empirical evidence or social science literature. There wasn't any out there. We didn't have experience with it. In Shrink Missouri Government PAC, the 2000 case, one of the questions before the court was what's the quantum of evidence, empirical evidence, needed to assess a legislative judgment regarding appropriate regulation? And the answer in Shrink Missouri Government PAC in 2000 is not a lot. We'll take almost anything the legislature throws at us. They looked at some testimony by a legislature, they looked at a few anecdotal newspaper articles, and they said, okay, this seems warranted, this kind of a limitation, about $1,000, to combat corruption, quid pro quo corruption, and the appearance of such. Contrast that with McConnell and with Sorrell. In McConnell, in the lower court, there were 100,000 pages of evidence from more than 200 witnesses, most of them expert. Sorrell has a very sophisticated analysis of the social science research where the court actually looks at the effect of certain levels of campaign contributions, not on the average race, which is what the lower courts did and what some of the dissents would do, but on competitive races. What does it mean for close races, for contested races, for competitive races? Referred to expert testimony in social science studies. This is very interesting. I think it shows that a lot of these justices were trained in the law school of today, the interdisciplinary law school where what we're doing in classes is talking about law and social sciences. There isn't doctrinal law being taught in the national law schools by and large. What we teach is laws policy and laws informed by empirical social science assessments. Justice Breyer used to teach that way. He still judges that way. And people like Roberts and Alito are very much in that kind of a vein of how you approach the law, and you can see it in these cases. What I think is a little bit interesting, though, about the use of social science is social science data is not conclusive on any of these issues. There's still a lot of debate in the social science literature about whether contribution limits increase competition, whether it doesn't. There are endogeneity issues. It's complicated, and it's not clear to me that even the sophisticated justices that we have on the court now can fully grapple with it. The second, I think, important thing about this opinion is that you see a real openness to arguments about competitiveness as a necessary condition of a healthy and functioning democracy. There's a lot of the use of social science literature to try to figure out how can we make our elections more competitive. That's a real concern of Justice Breyer in his book. I think it's a concern that you see in lots of his political process cases. How broadly it's shared is still not clear, I think. Roberts and Alito joined the opinion. Did they join the opinion because they like this competitive rationale? I don't know. And I'm a little dubious about the robustness of competition as a theme, because when we get to the partisan gerrymandering case, which really is about competition, not much discussion of it, not much use of social science, not much use of empirics. So if this was a robust theory, you would have seen it all over the case out of Texas, and you really don't see the same kind of approach there that you see in this case. It does, I think, though, mean that increasingly the justices are approaching these law and political process cases from structural perspectives, not from the older perspective of individual rights. that just as many of us have been arguing in the academy, people like Rick Pildes, Sam Issacharoff, Fred Schauer, have been arguing that the way to look at political process cases is how do you construct a structure that then works to ensure individual rights. That's what we ought to be about, and that's what the court ought to be about as it analyzes these cases. And whether you adopt competitiveness as a structure or other kinds of approaches as a structure, I think that is increasingly being seen in these cases, and you can see it in Breyer's plurality opinion. The final thing I would say about this opinion is that Breyer has a great deal of influence, not just on the substance of it, this competitiveness, social sciences, structural kinds of approaches, but in the methodology of the decision. And to that extent, I think it may be too bad for my area of the law because it leads to a very convoluted test, a lot of unclarity. Not only do lawyers, I think, after this case not know how to argue these cases, but I don't think lawmakers who are attempting to write constitutional statutes know what to do. And in this way, I think it's very much a Breyer approach. I am also an administrative lawyer, and those of you who do administrative law know that Breyer's approach in administrative law, which is his area of specialty, he loves standards, multi-pronged standards with lots of qualitative decisions, very hard to get your hands around it. Unlike Scalia, right, who likes bright line, clear-cut rules. It's sort of Meade versus Chevron, if you will. And here what you're getting is that kind of approach. So what's the test? Well, first you look for danger signs and contribution limits. Lower limits than have been upheld in the past or lower than any other state has. One limit per cycle as opposed to one limit for primaries, one limit for general elections. Applying the same rules to parties as to individuals. All right, fine, but how many of the danger signs do you have to have? What's the hierarchy? Are they the only danger signs? We don't know. We have no idea. We don't even know why these were picked as danger signs. Well, if you have those danger signs or some subset of them or some other ones that are not mentioned here, then you as a court do not defer to the legislature, but you do an independent examination of the record to see if the regulation is closely drawn to fit the governmental interests. And that's where all this empirical social sciences come in, and that's where Breyer decides he'd rather focus on contested elections than average elections, which is what the legislature and the lower courts did. So I think what you see is a lot of muddling up of this water, which is going to be a theme of mine as we look at these law and politics cases. I think we're going to see a lot more cases come up to the Court on Campaign Finance. I think it's wide open right now. We'll see disclosure cases come up. There are splits among the circuits. We'll see cases dealing with the initiative context where you don't have candidates and where the tests are slightly different. We'll see political party cases, because I think there are hints here that the political party cases could come out differently. We'll see challenges to some of the specifics of McCain-Feingold, like regulation of 527s, internet regulation. Lots of movement in this area. So the second big case comes out of Texas, all right? And it's a gerrymandering case. It's as fractured as the first, same number of opinions, but it's even longer. At first I thought I was really lucky to get only 3 cases relative to Irwin, but I realized I was not living right when I started reading these cases. So this case follows up on the 2004 case, Veith versus Jubilier, right? Another partisan redistricting, partisan gerrymandering case, where 4 justices said, look, we never strike these things down as unconstitutional. Davis versus Bandemare does not have a standard that we can apply. We ought to say that these are non-justiciable cases. Justice Kennedy writes an opinion in Veith where he says, no, I think we may be able to fashion a test. I don't know what it's going to be, but I'm not willing to say these are non-justiciable. So we're still open to some of these cases coming down. So we get the Texas case, and I think all of us who watch this thought, well, if any of these are justiciable, if any of these things are unconstitutional partisan gerrymanders, surely this is it. Apparently not. But still, we don't have 5 of them willing to say it's non-justiciable, just take these things out of this court, go to Congress, go to the initiative process, go to the legislature, but we're not going to help you. So yet again, we have unclarity, we have muddling. And again, we could have had more clarity here because this dealt with mid-decades since redistricting. Where, as one of the dissents said, the whole question is not whether the lines were drawn for purely partisan reasons, but whether the decision to redistrict at all was undertaken for partisan reasons. At least after a census, you have one uncontested reason to redraw, and that is to comply with one person, one vote. Maybe you also seek to entrench your own party or to entrench incumbents, but at least there's one reason to redraw the districts and that makes sense. In the middle of the decade, you don't have that reason. And it's clear that the entire reason that the districts were redrawn here was to give the Republican Party more advantage when it comes to elections and to decrease competition. It was a response to a Democratic gerrymander. Let's be clear, both parties do this. It was a response to a Democratic gerrymander in 1990, but it was a partisan gerrymander. But the court said we are not going to look with greater distrust at mid-decade redistricting. We don't see any reason to do that. We're not adopting that presumption. And as we look at this map, we can see reasons other than partisanship for drawing some of the lines, and what it does is sort of put into place something that better reflects the partisan makeup of Texas now. There's no discussion or much discussion in the plurality about possible social science work, symmetry tests and the like that could have been used. So again, it's a case where we don't get a very clear answer, but we're still going to have lots of litigation because the court didn't say what I think is the case, which is we are never going to find an unconstitutional partisan gerrymander. Do not bring any more of these cases. That's what Scalia wanted to say in Veith. It's what he wanted to say here, and I think it would have done us all a service if they would have said it. Now, I'm almost out of time, so I don't want to spend a lot of time on the racial redistricting aspects of these cases. I just want to mention two things. One is that even though I don't think partisan gerrymandering cases are ever going to be successful, it's important to remember that partisan considerations often play a role in cases that come to the court under the Voting Rights Act. So in this case, for example, we have one of the districts found to be unconstitutional under the Voting Rights Act was Bonilla's district, District 23, I believe, and a district that was redrawn to move some Democrats out of Bonilla's district and to protect a Republican incumbent. Now, those Democrats were Latino. And because of that, there was a claim to be made under the Voting Rights Act, and a successful claim here, that the lines of that district were drawn unconstitutionally and against the Voting Rights Act. So one thing to keep in mind is that partisan considerations also play a role in lots of cases where racial discrimination is at issue. The issue is that race tends to vote for one political party, so the lines are drawn to move them out and protect the incumbent of the other party. Final thing I would say is there's a lot being made of Robert's separate opinion, in part because of what Doug said. He didn't write very many. But I think in part because of its tone, and many people quote the line, it is a sordid business, this divvying us up by race, to suggest that Roberts is not going to be particularly open to some of the claims under the Voting Rights Act that the court has been open to in the past. I think that's probably right. He's not going to be as open, nor is Alito. But there's lots of that language. He talks about the fact that there are things in the majority, the plurality, that are blushingly ironic. Actually, this part of the opinion is majority, or he talks about the majority's fig leaf. There's just a tone in this opinion that is very hostile, and it's particularly interesting because I thought one of the interesting things about Kennedy's opinion on this particular issue, the question of the racial redistricting under the Voting Rights Act, is he actually didn't divvy people up by race. One of the aspects of his compactness analysis is that Latinos in Austin and Latinas near the Mexican border might not share a community of interest by virtue solely of the fact of being Latino. So that he's actually introduced into voting rights jurisprudence a new kind of consideration that, in fact, people of the same race or ethnicity may not share community of interest by virtue of living in different places, having different experiences, different viewpoints. There wasn't the divvying up by race that I thought would have prompted that comment, which suggests, if it was really unprompted, that what we're seeing here may be a real change in some of the voting rights jurisprudence that comes before the court in the future. Thank you again.
We have a question from Marcia Coyle.
Professor Garrett, I read my local newspapers. I try to read them every day. And one of the things I've noticed is there's been a lot of talk about problems with voting machines. And I'm wondering, as you look at the election cases, are we going to see, do you think, a return of Bush v. Gore? Not in the sense that the Supreme Court would be choosing a president, but when the Supreme Court decided Bush v. Gore, in the language of the opinion, it was deciding this case for this time. What have you seen happening out in the land in terms of litigation involving Bush v. Gore?
Yeah, of course, one of the most objectionable things about Bush versus Gore was that the court said this is not really a precedent. It's good for one case only. And the way you keep, in part, you keep a court modest. And I actually think it's very hard to keep courts or justices modest. They don't really want to be modest. They want to use power just like anybody else wants to use power. So one of the ways you keep them modest is you say, well, you make this decision here, you're going to have to be consistent. And there may be cases that come up where you have to apply this principle consistently, and you're not going to like the outcome as much. And so by putting that in Bush versus Gore, that's a real way not to be modest when you're a judge, because you don't have to be consistent over time, even when the result is not one you like as much as electing President Bush. So what's interesting, though, of course, is that the Supreme Court can't really control how its precedent is used unless it wants to take the case and, again, remind people, no, we were serious. It was a one-shot deal. That's it. And so what's been happening out in the country is that some of the lower courts and the Ninth Circuit in the recall election here, but not on an en banc reconsideration, but some of the lower courts are using the Bush v. Gore rationale to say that when you have voting machines that differ from one district to another within a state, or you have other practices that differ within a state and among districts, that treat people's votes differently, that could be a violation of equal protection. I think it could also be a violation of some due process. So there are constitutional infirmities with systems that don't treat people the same. It's never been quite clear to me why we aren't also concerned about having differences among states so that an Oklahoman's vote in a national election is treated differently than a person from Missouri. So it seems to me that if you actually take Bush versus Gore seriously, some of these problems in voting can lead to a great deal of judicial interaction with particularly a system that is so locally based as our system of voting. My guess is if that really starts happening to any great degree, the Supreme Court will take one of the cases, and we'll find out if they were really serious that this was a precedent that was good for one time only. They'll have to reiterate it, I think, if they're going to control some of the stuff that's happening in the lower courts.
Professor James?
Professor Garrett, one walks away from the Sorrell case thinking that Chief Justice Roberts wants to keep Buckley around basically to reflect his respect for stare decisis. Does this give us an insight into his general view on stare decisis, and can you comment on what we might look forward to in that regard?
Well, it is interesting, as I mentioned, I think, in my remarks, that he did not join Alito, who said, look, I'm not reconsidering Buckley because it wasn't necessary to this decision, it wasn't fully presented, but at least leaves the door open. And, of course, we have dissents that are very clear they would reconsider Buckley. On both sides, right? I mean, Justice Stevens writes that he also would reconsider Buckley, but he would allow lots more regulation to go on. And it's, you know, I think it is a very defensible position to say that the bifurcated system in Buckley makes no sense. Justice Marshall came to that conclusion at some point and said, but I think we ought to apply lesser scrutiny to both sides of the equation. I don't know, though, how much you can read into Roberts' decision to join the Breyer opinion in this regard, because I wonder if it isn't some of his walk softly and try to speak unanimously. You know, it just wasn't an issue that was fairly before this court. It was a case that could be decided in a way that Alito and Roberts thought was the right way without taking on Buckley. And one imagines that there are going to be plenty of opportunities in the future for them to reconsider it more squarely and more thoroughly.
My follow-up to that question before back to the cards, if one does away with Buckley, given your interests in providing certainty for state and local policymakers and then the PACs and folks who want to contribute, what do you replace it with? What kind of framework would you suggest?
Well, I think however it's replaced, you know, whether they overrule it in a way that Scalia and Thomas want to overrule it or overrule it in a way that, say, Stevens or perhaps Justice Marshall might have wanted, I think it would be more certain. And in that respect, I suppose either of those results would be better than the uncertainty we have now. My own preference, if you were to ask me, is to allow much more experimentation on the parts of states and the federal government, and for the courts to be extraordinarily deferential in this realm, as in many realms of political process, because I think that there are lots of ways. You know, the great thing about having lots of states in the United States is we actually can experiment with public financing in one state, with another state with relatively low contribution limits, with another state with just disclosure, but very aggressive disclosure. But that would be my best preference in lots of cases, including cases dealing with primaries. The blanket primary case, I think, was wrongly decided. I would have liked to have seen experimentation there, experimentation with respect to party regulation. That doesn't seem to be the court's preference, but it would be mine.
I see.
Counting to 5, you said you had difficulty doing that in the context of seeing Buckley overruled. There is, of course, Stevens, who would overrule it, at least in the direction of suggesting limitations on expenditure. Justice Souter and Ginsburg seem equally inclined in that direction by virtue of reminding people that Buckley didn't eliminate restrictions on campaign expenditures, talked about proving them by virtue of heightened scrutiny. You have no hope for the open mind of Sam Alito or John Roberts?
Well, I think Roberts, I don't have much hope for Alito. I think he clearly signaled that if this had been presented to him squarely, he would have joined Thomas and Scalia. Roberts is the mystery here for me. Roberts is the question mark. What does it mean that he wouldn't join Alito and he did join the Breyer opinion that talked about stare decisis? And that, it's hard for me to know. My guess is, given what I've seen so far, that he's more likely to be in the camp with Alito, Scalia, Thomas, and Kennedy. But I think it'll be interesting. I think what we have seen, though, is after McConnell, I think a lot of us in this field thought, well, we kind of see where things are going. A lot more deference. I never thought expenditure limitations were going to be held constitutional, but I thought almost anything with respect to contribution limitations were going to be held constitutional. There was going to be lots more experimentation and lots more leeway. I think now all bets are off. It's all unsettled again, and we're just starting all over again as we were before McConnell. We're going to have another big case come down to give us more guidance.
I guess I see Justice Alito's opinion a little bit more tentatively, indicating that he just didn't think the arguments had been presented, so kind of, again, a judicial restraint exercise. Isn't Stevens' argument about the effect of expenditures the one that the public understands the best? That, in fact, it is no longer possible for most of the people in this room to run for public office and to pursue it successfully?
I think that most Americans are very upset with how the political process is working, and they think things are very broken. But just as they understand that it takes a lot of money, whether your own or lots of expenditures, either independent or otherwise, from well-to-do groups and individuals to elect you, there also, I think, is the common sense notion, and this is expressed in Thomas's dissent, that it's hard to imagine that $201 is sufficient to corrupt a politician. And remember, that's the limit. Those are the kinds of limits we were looking at here, right? These limits do seem, in my view, again, I don't think they're unconstitutional, but do I think they're wise as a policy matter to put such strict limitations in as Vermont did? The answer is no. I don't see corruption at those levels. I think that's a common sense argument that Americans can understand. I also think that when we think about competition, I think that's a really interesting argument from just a common sense perspective. A lot of the scholars in this area think robust competition is great. That's what we want, really competitive elections. That's not what we have now because of gerrymandering. On the other hand, if you go out to people, they might like competition in the other guy's district, but frankly, they'd like to be able to be awfully sure that they can continue to elect somebody who's just like them and continue to put them in office. Bruce Kane has made this observation in the context of competition. The competition is one of those things scholars like a lot more than average Americans do. So I think the most you can say about average Americans in the political process is they think things are really broken. And that's why I think experimentation at the state level, more deference, more willingness to let lots of different things be tried would be a positive development for our democracy and for people's willingness to engage with it.
We now turn to the separation of powers, and I believe we hear from Justice Roberts.
Last month when I was home in Wisconsin, a constituent came up and said to me that he believed the D.C. Circuit decision in the Hamdan case, a different case, which you joined in to uphold the government's ability to try a Guantanamo Bay detainee by military commission, should disqualify you from being on the Supreme Court. Now this is apart from the issue that Senator Schumer and I wrote you about, which I'll turn to later. I want to know, with regard to the substance of the decision, why do you think someone would think that your decision in that case, why would somebody come up to me and say that your decision in that case should disqualify you from consideration as a Supreme Court justice?
Well, Senator, you've touched upon an area in which I cannot comment. That case is still pending. It's pending before the Supreme Court.
Not anymore. The Supreme Court, in a 5-3 decision, resolved the Hamdan case against the President of the United States and his effort to create a military tribunal system for purposes of trying those who are being detained in Guantanamo Bay, Cuba. While the majority opinion did not repeat the phrase that I referenced before, the President doesn't have a blank check, I believe Justice Breyer's concurring opinion did, in fact, repeat that phrase. It's a phrase that I think is worth unpacking a bit. The people who use the phrase have a tendency to use it as a bill of indictment. Their argument is essentially that President Bush has a hidden desire to be a monarch, that he, in fact, is disregarding due process, privacy, and the statutory limits of the law. They combine his decision to pursue a system of military tribunals with a whole list of causes in this bill of indictment, including his detention of enemy combatants, his use of a surveillance program to prevent attack, his tendency to write signing statements in which he indicates some qualification as to whether or not laws will be fully enforced if they raise constitutional problems in his judgment. In my estimation, this statement, as a policy matter, is both overstated, and as a legal matter, is overstated as well, and let me explain why. As a matter of policy, I think there is common ground that, in fact, we face an enemy alien for which there is a need to detain during the conduct of the war. I think there is common ground, as has been evidenced in the studies in Congress on why it is we were attacked on 9/11, that without a sufficient system of surveillance, we will not be able to prevent attack. I think there is common ground that there is an understanding that the Constitution is indeed the supreme law of the land, but it is also not a suicide pact. And I think we also have common ground that those who are being detained at Guantanamo Bay, Cuba, should be fairly handled in a responsible way, in a way that is accountable to our traditions as well as to the traditions observed by all free people. So, on a matter of policy, the bill of indictment against the president seems to me to be wrong-headed and mistaken. What about the law? If one reads Justice Stevens' majority opinion striking down the military tribunal system, one gets the impression that no one advising the president, identifying himself or herself as a lawyer, actually went to law school. But the law is much closer than that. And let me suggest some apt quotations that I think illustrate that. We are all familiar in this area with the Youngstown case. It is frequently cited. It is cited for the famous 3 categories in Justice Jackson's concurring opinion. You know the ones. When the president acts together with Congress, he acts at his zenith of authority. When the Congress has not spoken clearly and the president acts, he's in the twilight zone. And when the president acts contrary to wishes expressed by Congress, his authority is at the lowest ebb. That is a useful rubric. Everyone in this room who's ever taken notes in a constitutional law class likes a 3-pronged test, and they like categories. It adds clarity to the otherwise mushy discussion that is occurring. And so when Roberts and Alito were pressed time and again to explain their position about whether they actually defended the nefarious unitary executive theory when they worked for President Reagan, a theory that, of course, is traceable to Alexander Hamilton and Federalist Paper number 70, that, in fact, they recurred, as all others recur, to Justice Jackson's categories. But there's 2 other things recited in the Youngstown case that were cautions surrounding the use of these categories for purposes of analysis. First was a separate opinion by Justice Frankfurter, who said, you know, it's rather unprofitable to lump together in an undiscriminating hodgepodge past presidential actions claimed to be derived from occupancy of the office as to conjure up some hypothetical future case. The judiciary, said Justice Frankfurter, may have to intervene from time to time to make sure that boundaries are observed, but if we do so, we should be, in Frankfurter's words, wary and humble. Such is the teaching of this court's role in the history of the country. The reason Hamdan is a headline case, perhaps the headline case for this term, is because that precept, the precept of courts being wary and humble and intervening with the decisions of the political branch in matters of foreign affairs, was tossed aside, and tossed aside as if, in fact, it was a regular thing to do. Justice Jackson himself, the same author of the categories that we find so useful, said, "A judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to the concrete problems of executive power as they present themselves. Just what our forefathers did envision or would have envisioned had they foreseen modern conditions, had they foreseen towers attacked by commercial airliners on 9/11, said Justice Jackson, is as enigmatic as the dreams Joseph was asked to interpret for the Pharaoh. One can find, said Jackson, more or less apt quotations from respected sources on each side of any question. My point in all this is to say that those who use so handily the supposition that the president does not have a blank check and smugly assure themselves that, in fact, they have properly put this man in his place, have simply not consulted the law of the United States and the difficulty of resolving questions that have confronted this nation since it has been attacked in September of 2001. Hamdan, in my judgment, is the anti-Roberts. It is the antithesis of humility, consensus, and respect for precedent. Roberts, of course, can't be blamed for it. He was recused. But the admonition is, don't leave the building anymore. And don't take my word for it that this is an extraordinary break from precedent. I ask you to take the word of a friend of mine who sees the world entirely differently. And you think I'm going to quote Irwin, but I'm not. There are many people in the Academy who see the world differently. And one is Professor David Cole at Georgetown, who has been a strong opponent of the president's exercise of authority in this area. And in the New York Review of Books, Cole writes this: "To say that Hamdan faced an uphill battle is a gross understatement. In light of past precedent, in light of the enemy alien status of the defendant, in light of the timing of the lawsuit before the fairness of the military proceedings themselves could even be assessed, in light of the fact that there was a congressional law that seemed to deprive the court of jurisdiction, it's a surprise they won. The fact that the court decided the case at all in the face of Congress's efforts to strip the court of jurisdiction is remarkable. Listen to those words: uphill battle, setting aside past precedent, unripe, remarkable disregard of jurisdictional limits, break from historic deference. President, asking for a blank check? I think this is more of a case of the judiciary being involved in executive identity theft. Hamdan is a 178-page opinion. I urge it upon all of you. But in a nutshell, in case you don't have the time for that this afternoon, Justice Stevens simply found that the military commissions were neither authorized by statute and they were contrary to international treaty. Now, of course, Justice Stevens has been active in this area. He is, as I reported when I did my overview comments, unlike Justice Roberts, who was largely in the majority of most of the cases decided this past term, Justice Stevens was the most frequent dissenter. He was the least likely to agree with the rest of the membership of the court. But he did get a 5-4 opinion in the previous term in a case called Rasool versus Bush. And even though there was a precedent known as Johnson versus Eisentrager from World War II that said rather plainly, nothing in the text of the Constitution or in the statutes of the United States confers a habeas right on aliens outside the territory of the United States, Justice Stevens found exactly that. Well, that came to the attention of Congress. Congress noted that 5 justices on the Supreme Court found a statutory habeas right, and in fact, they reacted to it. They passed the Detainee Treatment Act of December 30, 2005, in which they wrote, and I quote, "No court, justice, or judge shall have jurisdiction to consider the habeas application of Guantanamo Bay detainees." The court took that language, no justice, judge, or court shall have jurisdiction, and changed it to every court, justice, or judge shall have habeas jurisdiction if the habeas pleading was pending on December 30. Now, Justice Scalia looked at that interpretation of statute, which, as you might imagine, angered him because it relied upon legislative history, but also angered him because he declared it to be patently erroneous. Now, Justice Stevens is an intelligent man. It was not patently erroneous. It was a closer question than that. In point of fact, Justice Stevens looked at this jurisdictional stripping statute and pointed out that with regard to 2 provisions of the statute, Congress had specifically provided for retroactivity. But with regard to the general provision which applied to Hamdan in this case, they had not so provided. And Justice Stevens, applying fairly well-settled negative inferences, found, in fact, that Congress, treating those 2 things so differently, allowed the court to treat them differently as well. Now, I think there is obviously an argument on the other side. The argument on the other side is a presumption going back some centuries that a law repealing jurisdiction without any reservation as to pending cases applies to all cases, pending and future. I know this law, I know this case, I know this precedent, because it was written by Justice Stevens in 1994 in the Landgraf case. Now, before sitting down and taking my lumps, what would be the president's reasoning in thinking that he had authority to create a system of military commissions? What is this man up to? Well, there's a number of things that I think affect his thinking. First, he is of the firm belief that al-Qaeda are unlawful combatants, that they are, by every standard of international rule and practice, individuals who aim their fire not as responsible, honorable soldiers, but as pirates and barbarians who aim their fire at civilian populations and target them deliberately, who fight not in uniform, who fight not with open weapons, who fight not with a command and control structure, but in fact fight in a way that is deliberately designed to endanger both the civilian population and the military men and women who are then put in this tremendously awkward circumstance of having to fight a war in the context of residences, in the context of schools, in the context of hospitals. I think the president is motivated to have a legal system address that type of fighter, a fighter that doesn't observe the law of war and has been so motivated from the beginning. I think the president is also concerned about the integrity of the criminal justice system. Yes, it is true, if we wanted to fight the war by criminal prosecution, we could have attempted it. We did attempt it several times. There was a World Trade Center trial that lasted a good number of years in New York that disclosed, among other things in the public record, that if an commercial airliner hit the World Trade Center, it would destroy it. There are some risks proceeding by the normal criminal process intended to prosecute mafioso when in fact you're prosecuting a different type of human being. We also know that the system has a tendency to get distorted. Zachariah Moussaoui is indeed serving a lifetime sentence. He did have a criminal process, but it's not one recognizable to the Sixth Amendment. His ability to confront witnesses and to have the evidence he needed for his defense was in fact denied as a matter of national security in terms of his access to Ramzi bin al-Shibah and Khalid Sheikh Mohammed and the others who would have had information about his involvement. So what did the president think gave him authority? Well, I think the unique context of what I just described animates it. But if he wanted to point to legal authority, I'm certain he would say Article 2. The fact that the Constitution calls me Commander-in-Chief, the fact that the Congress of the United States, through the authorization for the use of military force, recognized that the war power had been activated, the fact that going back to Federalist Number 70, our founders recognized that the only sure way to have a defense against external and foreign invaders is to have somebody in this political system who could act with unity and dispatch and energy. I think he would point to all of those things, and of course he did in his briefing. And in 178 pages, however, there wasn't room to deal with that argument. The court simply said, we simply see no reason or no need to resolve that, since the military commissions authorized by the Uniform Code of Military Justice would be, in our judgment, more or less sufficient, and you haven't demonstrated, Mr. President, the practical necessity to depart from that model. Now, that's not an unrespected view. It's not a far-fetched view. It is, however, a view of people who I think are in the least position to know. It puts the judiciary in the position of directly challenging the executive where the executive is in its strongest posture. But let me end with Justice Jackson. Justice Jackson said, and you will be familiar with this quip, that the justices are not final because they are infallible. We are only infallible, said Justice Jackson, because we are final. That's a good quip. It says a lot. I guess my plea to the Supreme Court of the United States, as they toss around the sobriquet that the president doesn't have a blank check, might remember that in a democracy, to assume finality or infallibility on the part of any of the three branches is fundamentally mistaken. That assumption ends constructive dialogue and makes the correction of human error far less likely. John Roberts told us that no one ever goes to a ball game to watch the umpire. John, if you're watching, sometimes it's important to go to the game to keep your eye on the umpire. Thank you very much. Fire when ready.
I'm not sure I understand the big problem here. In November of 2001, 2 months after the 9/11 attack, President Bush put out the executive order saying, we need a new system to try terrorists. These people are not citizens, they're accused terrorists. I don't know anybody around the country then or even now who disagreed with that. But I don't understand what the Supreme Court ended up disagreeing with is why didn't he ask Congress for, if you're going to create a new system for trials, why not get legislation? Why didn't the Bush administration ask Congress to pass some bill that would essentially authorize the military tribunals?
You know, I think sitting in 2006, David, that looks eminently rational. I think the president's perspective, and I think the legal advice he was getting, was basically saying two things. First, an examination of Title 10, I guess it is, in which the Uniform Code of Military Justice appears, demonstrates that the Uniform Code of Military Justice itself, as an existing body of statutory law, does not preclude the creation of military commissions, and in fact specifically authorizes military commissions different from court-martials, with the admonition that the crimes that will be tried before military commissions will be those recognized by the laws of war, and with the further admonition that the military commission, wherever practicable, follow the rules of procedure that apply in court-martials. I think just on that legal question alone, the president could have been responsibly advised that he had, separate and apart from whatever inherent authority is existing in Article 2, statutory authority based upon a finding, his judgment, that it was not practicable to gather evidence in the same way against terrorists as it is to gather evidence of a street crime where you put yellow tape around the scene and everybody stops and everybody on PCH just camps out for the afternoon. And so based upon that statutory analysis, I think he would think he had authority under Title 10. There's the separate statutory argument about the AUMF, which, as you know, is extremely, it is sweeping in its terms, all necessary and appropriate force. If you read the AUMF against the history of military tribunals, as a recent historian at Columbia has done, one of the things you see is that there has never been a Supreme Court ruling against the president in time of war, specifically with regard to questioning his military tribunal authority, going back to the trial of Andre by George Washington, coming forward to Lincoln's use of these tribunals, to Wilson, and so forth. So, yes, would a specific statute have been nice and neat and tidy? I think so. Would it have been implausible and irresponsible for the Office of Legal Counsel to advise the president that he had statutory authority? I think not. I think that was a responsible argument to make, especially close to 9/11.
Can I ask a question?
Sure.
There are some who say that Hamdan makes clear now that the president lacked authority for the domestic surveillance program.
Right.
And I was wondering, because of its the reliance on the AUMF, and I was wondering if you see it that way. I see Erwin nodding his head. Well, maybe he has an opinion, but I was wondering if you see it that way. And also, I mean, it does appear that eventually that question will get to the Supreme Court, judging by the litigation around the country right now. Knowing that the Chief Justice was on the side of presidential power in Hamdan in the lower court, sort of reading an inkling into how he views presidential authority in his dissent in the Oregon case. Well, what do you see the fate of a challenge to the NSA program before the current Supreme Court?
On the terrorist surveillance program, Judge Anna Diggs Taylor in the Eastern District of Michigan did find it unconstitutional, as you report. She found it to be a violation of the Fourth Amendment as well as the First Amendment, and found it not to be authorized by the authorization for the use of military force. The President, of course, I think, will continue to make the argument that the AUMF is broad enough to support that authorization. I think in the context of that litigation, unlike the support I just illustrated for military commissions, I think that is a much harder argument to make. Saying that, in my candid moment here, I think one examines the full context and one cringes to come to that conclusion for the following reason. FISA, the Foreign Intelligence Surveillance Act, which to some degree governs the ability of the President to get warrants to gather foreign intelligence against foreign agents, was largely a statute designed to address the problem of domestic security. Justice Powell was very clear in the opinion to say that's what he was talking about. When they got to the issues of war and peace, there were substantial constitutional objections raised by, I think it was Edward Levy, who was then Attorney General, to the effect, no, maybe it was Griffin Bell. Griffin Bell? Okay. Griffin Bell, who made the proposition that the President would need authority in wartime to conduct military intelligence. And the way Congress responded by that was by creating, as you know, a 15-day exception for war. Well, no one seriously believes that you can complete a war in 15 days, at least not the way we're fighting it presently. And given that, what those 15 days envisioned was another statute. I think the President will continue to argue that the other statute is the authorization for the use of military force. But there's another problem with the case going up to the Sixth Circuit, and that is the core of this program has not been discussed publicly. The general outlines of the program have, but whenever Alberto Gonzales or any other member of the administration has discussed this program, they have been very careful to say, we can't tell you about the data mining and the cross-matching on computers that we're doing to identify the suspects that give us the initial pool of people that we then want to listen in on their conversations to see if they're talking about attacking us. That's my speculation, the data mining, data matching point. That part of the speculation in the Eastern District case was declared by Judge Taylor to be a state secret. I think the appellate court, looking at the fact that the operational heart of the terrorist surveillance program is not known and is in fact guarded as a state secret, may well dismiss the case on those grounds. And if that is the case, it's not going to get to the Supreme Court of the United States. Erwin, I know, disagrees. We should give you time to disagree. Disagree.
I'll be very brief and try to focus on Marcia's excellent question. To me, this is all about the issue of... To me, the issue is... I know. To me, the question is the President above the law? I think what's consistent about the examples we're talking about here and others is you have a President who's claiming that he can violate the law and not be checked by any court. This is an administration where there's a memo written saying that the President can authorize torture even though there's a treaty and a statute to the contrary. This is a President who's claiming the authority to detain American citizens apprehended in the United States as enemy combatants without having to comply with the Fourth, Fifth, and Sixth Amendments. With regard to the military commissions, this is a President who is claiming that individuals can be detained indefinitely in Guantanamo, even tortured, and there'd be no court able to review it. This is a President who's claiming that there's no authority of courts to check warrantless electronic eavesdropping, notwithstanding the Fourth Amendment and a specific statutory provision, the Foreign Intelligence Surveillance Act. So I think what's omitted from Doug's presentation is the extent to which this administration is claiming unchecked power in a way that's really unprecedented. Now, that's my transition to Marcia's question. I think there's a very strong parallel between what the Supreme Court did in the Hamdan case and what it would be likely to do with regard to electronic eavesdropping. The reason is, in Hamdan, the Supreme Court said there's statutory and treaty provisions on point. The court said that the Uniform Code of Military Justice and Common Article 3 of the Geneva Accords were directly on point, and that the president was violating these, and that was impermissible. The court was unwilling to regard the general authorization for use of military force as enough. Well, now put this in the context of electronic eavesdropping. There's a constitutional provision on point, the Fourth Amendment, that requires intercepting of conversations to have a warrant, except in very narrow exceptions that aren't present here. Also, the Foreign Intelligence Surveillance Act says all electronic eavesdropping either has to meet the procedures of that statute or another federal statute, Title III Anonymous Crime Control Act, and neither were met. So what is the executive claim here as to how it can violate the law? Two things. One is inherent presidential power. The president has the authority, just by virtue of being president and commander-in-chief, to authorize searches without complying with the Fourth Amendment. But I don't think the court's going to buy that because there's no stopping point to that argument. If the president can authorize electronic eavesdropping without a warrant, can he authorize federal law enforcement to go into people's houses without a warrant and to search there? If president's powers can trump the Fourth Amendment, why not the First Amendment? In fact, if the president has this authority, why can't he even cancel elections as mandated by the Constitution? Where's the stopping point to the president's claim of power? The other claim the executive makes is the authorization for use of military force. But there, to go back to your question, I think Hamdan is directly on point, because that's where the court says it's not a blank check. A general authorization for military force doesn't mean the president can do anything the president wants, like creating military tribunals or authorizing electronic eavesdropping that violates the Constitution and federal statutes.
Of course, Justice O'Connor, in her plurality opinion in Hamdi, said the authorization for the use of military force includes the necessary incidents of war, which she described as the capture, detention, and trial of enemy combatants. So there are some things that are read into this general authorization. Bob, did you have a question before we move on to the next?
The audience members, I'm afraid, share Professor Chemerinsky's skepticism. A couple of questions. I'm just reporting here. Here's one. You seem overly sympathetic to Bush having his blank check returned. Have there been any recent cases where you feel Bush has tried to play monarch, or do you feel he has included all pertinent voices the law of checks and balances required? Here's another. Isn't the military tribunal system intended to permit the U.S. to indefinitely detain individuals suspected of terrorist intent, but in the absence of sufficient evidence of either overt acts in support of terrorism or a conspiracy to commit terrorism? In short, to detain virtually anyone at the wisdom and discretion of government. Another audience member said that you've justified President Bush's establishment of military tribunals that take jurisdiction away from the judicial system by saying, quotes, the president is motivated to have a legal system, end quotes, but the president is not in charge of the legal system. He is limited to the executive system. So doesn't your argument demonstrate his lack of authority for military tribunals? I could go on there.
No,
stop to get your response.
Those are all good questions.
Okay.
I will say that, I have been troubled on occasion by some of the legal analysis that I think the president has been given, especially on the matter of interrogation practices. I think that started things off on a bad foot. On the other hand, I also think it's important for those of us who criticized in 2006 to remember the circumstance in 2001 and 2. Not that that's an excuse for bad legal advice or extending beyond legal authority, but to nevertheless consider the context. I think that is just simply a human plea. With regard to putting himself above the law, I don't think the president has that desire. And I think, for example, the most recent condemnation by the ABA of the President's use of signing statements was most unfortunate and most imprudent, a fact shared in not just by me, but by the fact that the ABA's resolution was challenged in its wisdom by our friend Lawrence Tribe, who was with us for the last conference, challenged by Walter Dellinger, challenged by every member of the Office of Legal Counsel in the Clinton administration, and for this simple reason, that the President has an obligation to take care that the laws are faithfully executed, and the laws include the Constitution of the United States. And as I think it was Walter Dellinger who wrote in the New York Times, if Congress enacted as part of an omnibus bill that the ABA president should be arrested and detained indefinitely, he might want the President to note in a signing statement that he didn't intend to enforce that provision. We now turn to the business cases and the commerce cases, and for purpose of doing that, we are introduced by Justice Alito.
So my question is, does the recent Supreme Court decision in Raich, joined by Justice Scalia, whose opinion you said was closer to your view than the other, affect your thinking? More specifically, had Raich been decided before you got Rybar, do you think you would have decided it differently?
Well, Senator, I don't recall making a promise that I would reach a definitive conclusion on the issue.
I asked you to think about it. You said you would. That's all.
And I have thought about it. But what I can say is that I certainly would have thought about Rybar differently had I had Raich available at that time. My effort in Rybar was to follow Supreme Court precedent. At the time, Lopez was the latest expression of the Supreme Court's view of this question. And if the chronology had been different and I had the benefit of Raich, I would have taken that into account.
Good. Okay. Now, just one other thing on the Commerce Clause. So what you're saying, I just want to, there's a possibility, we won't put a percentage on it, that Raich might have changed the outcome of your ruling in, or your dissent in Rybar.
Well, it certainly would have changed my thinking and my analysis. I would have had to take it into account.
We'll take what we can get.
Ladies and gentlemen, it's my privilege to introduce someone who has brought great intellectual life and many gifts to this law school. My only regret in the introduction is that the title he uses is Dean rather than Justice Kenneth Starr.
Oh, thank you. Thank you. Thank you. Thank you. Well, thank you, Professor Kamek. Well, we've been treated thus far to a great conversation, at times a great debate. We've discussed issues of war and peace, individual rights and liberties. Should the Fourth Amendment exclusionary rule be abandoned? The political process. I'm here to talk about the business cases. Now, I have been assigned this topic, but I take it on with gratitude and with enthusiasm, and I'm here to convince you that the Supreme Court should be doing more of what I'm talking about and less of what my colleagues have been talking about, because they do less damage. Let me say that I will take the opportunity, if my distinguished chair and dear friend, Professor Kamek, will allow me, to say a few things more broadly about the Roberts Court along the way, and then a few things even about the Rehnquist Court as we look back and salute our fallen late Chief Justice. So what did the court do, and what can we look ahead to in connection with what Calvin Coolidge famously said, "The business of America is..." Now, whether one agrees with Mr. Coolidge or not, we begin this part of our afternoon reflections with a reminder that the court during Chief Justice Rehnquist's stewardship was not, in the views of many, particularly interested in business cases. Will the Roberts Court be different? I confess that almost exactly 13 years ago, I authored 2 consecutive op-ed pieces in the Wall Street Journal, suggesting at that time that the court was not taking enough cases, that it should take more cases, and that at all events, the court should not be allowing circuit splits to fester, especially in arenas of law where labor, management, others needed guidance. My 2 pieces clearly had a remarkable effect. Not quite what I wanted, because after they were published, the court started hearing even fewer cases, especially with the retirement in the early 1990s of 2 leading members of what I considered and applauded as circuit conflict police officers, Justice Byron White and Justice Harry Blackmun. Few, if any, voices on the court were raised to the effect that the justices ought to be more energetic in terms of quantity, not necessarily writing 176 pages in a single case, but especially to take more seriously the responsibility to eliminate instability flowing from unresolved conflicts that were infecting the vast body of federal law. Well, it's a new day, and we have a very vigorous new Chief Justice, well known for his energy and his work ethic, and who seems, in view of statements at the confirmation hearings during a colloquy with Senator Cole, to be of the view that the court should indeed take more cases. I'm here to say that's a good thing. And let me say why. In his very provocative foreword to the Harvard Law Review's Supreme Court review of the 2004 term, a term which proved to be the final chapter in the Rehnquist Court, with the Venerable Chief passing from this life on September 4th of last year. Judge Richard Posner, who was dubbed by William Brennan as one of 2 geniuses with whom he had had the privilege to labor or watch during his many years, indeed decades, on the Supreme Court. One was William O. Douglas, and the other was his law clerk, Richard Posner. Judge Posner argues in the Harvard Law Review that the Supreme Court has become more politicized because it fails to take everyday, prosaic cases. It simply turns a blind eye. It doesn't care about them. Let Judge Posner's words speak for the judge. Quote, "The more that constitutional law dominates the court's docket, the more that appointments to the court, as we've seen, focus on the candidate's likely position in constitutional cases rather than on competence in a vast range of fields." Now, I believe and submit to you that the Posnerian charge should be deeply troubling, especially in view of, okay, let me summon them to the witness stand, opinion polls. Commissioned by the American Bar Association, also polls by the Gallup organization that suggest a strong perception years after Bush versus Gore that the Supreme Court in particular, and that indeed courts more generally, are actively pursuing political agendas. An American Bar Association poll conducted just exactly 1 year ago showed that 56%, this is the ABA, 56% of Americans believe, quote, judicial activism has reached crisis levels. Another poll, this one conducted by Gallup only 3 months previously in summer of 2005, showed that a historic low 42% of Americans approved of the way the Supreme Court was handling its job. Now, that's a year old before the unveiling of the Roberts Court. This is not good. In fact, it is more. It is profoundly unfortunate and disquieting to all of us who love the court. It is obviously indicative of an erosion of public confidence and certainly has the potential effect of eroding a bedrock value of judicial independence lifted up by Mr. Hamilton in Federalist 78. So even if one is not interested in the workaday world of business cases, perhaps there are reasons why those who do wish the court well might be pleased to see the court do more Posnerian type work and to take fewer of those CNN breaking news headline makers, or as my distinguished visiting professor colleague Grant Nelson might say, who used to teach constitutional law, he now teaches real law. Now, it looks as if that may be happening. One swallow doth not a business spring make. But looking ahead to the early months of October term 2006, it appears that the court is actually going to be hearing more of these Posnerian cases, rather than looking for new constitutional frontiers to march into and further politicize the court. I could give examples, but time fails me. Check the listing of what the court is scheduled to hear. By my count, already on the docket, 11 hardcore, quote, business cases. But let me focus in my brief time remaining on 6 cases, which those of you who are here for CLE credit, you have in your materials, and draw from these quite varied cases some broader themes about the Roberts Court, and I'm going to call it that, during the rookie year of our new Chief Justice. The first theme is that the Roberts Court at this early stage surely cannot fairly be characterized as pro-business, even though no fewer now than 7 of its members, have we forgotten? 7 were appointed by presumably business-friendly Republican presidents as early as Gerald Ford. Now consider, for example, a major employment discrimination case under Title VII, Burlington Northern versus White. The court ruled quite emphatically in favor of employee rights in the face of a strong push by the business community, including the U.S. Chamber of Commerce, to go in exactly the opposite direction. The court was unanimous in its judgment in favor of the employee, Sheila White, who claimed that her employer, the railroad, had retaliated against her in 2 ways. Now, this was an example of the court stepping in exactly where it should. The courts of appeals were in disagreement with respect to the standard that guides retaliation as an actionable part of Title VII, and that's what the court should do. But in doing so, in the White case, the court fashioned a quite far-reaching, and some would say, and have said, litigation-producing standard that quite generously widens the reach of employee protections. One employment lawyer who advises the management side of the House was quoted by our friend and colleague in the Fourth Estate, Linda Greenhouse of the New York Times, as saying that the decision would have a, quote, huge effect on the American workplace. But whatever one's views, I think one thing is clear, that this is a very important area of the law for the court to be interested in. Retaliation claims happen to be a very dynamic part of employment discrimination law, and the Burlington Northern decision will now serve, I think, as a growth engine. Now, that may very well be a good thing in terms of progress toward a discrimination-free workplace, but it is, my point, not a pro-business decision. I also hasten to cite, I will not discuss, as I had hoped to do, the separate solitary concurrence in the case by Justice Alito, the court's newest member, who shows in that separate concurrence he agrees with the judgment but disagrees with the standard articulated for all 8 members of the court who spoke through the quite powerful voice of Justice Breyer. So is the Roberts Court good for business? Consider the major property rights related term. We've already discussed this a bit. Remember when we concluded last term, the nation was abuzz with Susan Kalo and her plight in New London. Does everyone remember that? Well, the huge property rights case of this term, again referred to already, Rapanos versus United States, was decidedly not a victory for the business community. The issue was whether the Army Corps of Engineers, on behalf of the federal government, could control the land development activity of Mr. Rapanos in Michigan. And it called upon the court to interpret a very important part of the Clean Water Act, the waters of the United States. So that's our term. what is meant by the waters of the United States. Now, we've talked in our conversation thus far that it appears that in the Roberts Court, unanimity is valued. But as we talked about the Texas Ten Commandments case and so forth, where the court has been divided in the past, well, this was one of the huge divisions. The court was divided 4-1-4, with a justice in the middle being the justice to watch, Anthony Kennedy. Now, 4 justices, speaking through Justice Scalia, and I think his opinion is worth reading in terms of methods of statutory interpretation that are likely to be in the ascendancy in the Roberts Court, rebuff the Corps of Engineers' efforts to regulate what John Rapanos was seeking to do. You see, Mr. Rapanos' land with water on it, called them wetlands, was some 11 miles away from the nearest navigable waters, 11 to 20 miles, depending on where you were measuring. Now, the plurality opinion by Justice Scalia very colorfully jousts with his colleagues over the interpretation of this pivotal language, waters of the United States. What does it mean? And the plurality, as the court tends to do these days, takes us on a journey through dictionary land. Have your Websters handy, but even a charming quotation from the movie Casablanca, to the effect that as the plurality saw it, the Corps of Engineers was seeking to perform a sort of reverse Red Sea miracle by turning land into water. But no water, no jurisdiction by the federal government. It would become a state and local issue. The plurality invoked values of federalism, which is one of my sub-themes this afternoon. The Clean Water Act, passed by Congress in 1972, was, after all, an experiment in cooperative federalism, with the states, as in the Clean Air Act, retaining very significant responsibilities for the development of land and the protection of water resources. But as the plurality saw it under the Corps' regime, federal control was open-ended and far-reaching. And the plurality concluded that this was inconsistent with not only the language of the statute, land is not water, but it intruded too deeply into traditional state and local control over land use development, echoes of Susan Kalo's case. Now, the dissenters, led by Justice Stevens, relied less, quite overtly, on statutory text and more on policy considerations, so considered a pragmatic approach of the desirability of greater environmental regulation. Wetlands are very important. They support habitats for animals and obviously do play a very important role in reducing pollution. And that fact, according to the dissenters, should in fact empower the Corps of Engineers to very generously interpret the Clean Water Act in ways that might seem, on the surface, as it were, counterintuitive, namely to regulate activity on land that was many miles away from navigable waters. So that left Justice Kennedy as the person in the middle. And happily for lawyers, his approach requires a very litigation-rich, case-by-case determination. So we're very thankful to him. He has articulated his own significant nexus tests, so call on the experts as well. We litigators love this sort of thing. Let me pause for a second and say that in understanding this early term of the Roberts Court, I think there was a critical opinion in this case that has been largely overlooked in my review of the commentary. It really was a cry from the heart of the new Chief Justice. He wrote a solitary concurrence in this land is water case. And he lamented that the court's house was so divided and had left the state of the law muddled and confusing. But the chief is very smart and very skillful, so he took his aim not at his colleagues, but at the Corps of Engineers, for what the chief seemed to be saying, my description, an imperious or at least insouciant attitude, we can do whatever we want to do. I'd rather thought the Corps of Engineers is a rather nice shop, but apparently they are power mad. Now, all this confusion could have been avoided, in the Chief Justice's view, if the Corps had developed through regulation, some notion of the outer bounds of its authority. Do you see the echoes of what we were just talking about? It had not done so, and so now planning commissioners, real estate developers, property owners, and the Sierra Club are left to languish in uncertainty. It was all unnecessary. So perhaps on that mid-June day when the court issued the Rapanos opinion and the court was looking ahead to rising for the summer recess, the chief was actually saying to his colleagues, don't do this. We can and should do better. Let's try not to be a judicial house of Babel. And encouraging the court to speak with greater harmony does appear to be, and this came through in his confirmation hearings, a very high value. Will it work? Well, in one closely watched business case involving almost everyone's friendly online auctioneer, eBay, admitted you have been selling things on eBay. The court was, and that's a good thing, welcome to the vast commercial marketplace, which the founders envisioned. The court was unanimous in rejecting a rigidity that had developed in a very important world of intellectual property. Over time, a rule had evolved in the nation's very important and not sufficiently understood patent court, the Federal Circuit, that absent the most exceptional circumstances, courts are obliged, once patent infringement has been found, to issue a permanent injunction, as if the night follows the day. Not just money or royalties, but an injunction that says to the infringer, stop it and stop it now, don't do it anymore. It seems very sensible. But this automatic injunction rule of the Federal Circuit had actually represented a departure from the traditional role of equity. What is supposed to happen, as law students know who've had remedies, is that the judge is to make a very holistic determination, applying well-settled four-part standards, and to come to a conclusion whether an injunction really is necessary. Won't writing a check do the job just fine? But this automatic injunction rule that the Federal Circuit had fashioned had, in the views of some, helped foster a cottage industry referred to pejoratively, and I hope I don't give offense, patent trollers, those who go out and very avariciously gobble up patents for not producing and selling goods, but for obtaining license fees. In eBay's view, that was exactly what was happening to them, and they viewed it as a sort of form of entrepreneurial, creative extortion. Now, let's be clear, being a patent holder but not practicing the patent makes lots of sense for universities and inventors and so forth. And Justice Thomas, for the unanimous court, took all this into account. So what to do? The unanimous court said, the traditional rule applies, no automatic injunctions. Federal Circuit, please no more of this. This is a very important one, and it's a unanimous one. But there was a very revealing drama within the eBay case. It went not unnoticed. And that is the battle of those pesky concurring opinions. There was unanimity on the surface, but a disagreement erupted, and here the battle was brought on, ironically, by the unanimity-seeking Chief Justice. He had obviously assigned the opinion for the unanimous court to Justice Thomas, and Justice Thomas wrote no automatic injunctions. But the Chief then crafted a very short two-paragraph concurrence that said, and we know the new Chief Justice loves history, okay, yes, let's return to the traditional test, but when we look historically at what has happened in these cases, injunctions have been issued in the, quote, vast majority of patent cases where infringement has been found. And by this little concurrence, the Chief seemed to be putting his very impressive and formidable thumb on the scales of judges go ahead and grant injunctions. Not automatically, but that's what has been done. And he must have been delighted to receive the news in the court, please join me memos from Justices Scalia and Ginsburg. That's very good. Life is beautiful. But He then received Justice Kennedy's concurring opinion, responding to and very politely but firmly disagreeing with the Chief that two-paragraph offering must have caused the Chief to remember those marvelous words from the Righteous Brothers song, thinking of Anthony Kennedy, "You've lost that loving feeling." Justice Kennedy said, in effect, in this setting, history bah humbug. The economy and the information age is now infected with these patent trollers. They're everywhere. They're simply out to make a buck. And for them, writing a check is quite enough to compensate them, but don't allow them to hold up the product of service. And this was the voice of Silicon Valley, of Route 128, and I have been told to stop. Please don't take too seriously my whimsical observation about history, because if time permitted, and it obviously does not, I fear what might happen if I continue to violate the stop sign. But in the case, which I will say 1 minute about, Central Virginia Community College versus Katz, here was a case that did, in fact, connect the business cases to the great issues of federalism that I had hoped to speak about. In this case, Wallace's Bookstores, which did business with Central Virginia Community College, among other state colleges, went bankrupt. The business was being liquidated, so the bookstores are going out of business. And the liquidator, Bernard Katz, appointed by the court, looks around and sees that the bookstores had made certain transfers to this community college that the bankruptcy code would forbid, so-called preferential transfers. And Central Virginia Community College said, in effect, Mr. Katz, you cannot sue us because we're part of the Commonwealth of Virginia. Please go away. The Supreme Court said, college, Mr. Katz does not have to go away. In a historically rich opinion authored by Justice Stevens, the 5-member majority looked to the Constitutional Convention of 1787, early cases prior to the convention, to bankruptcy laws passed at the time of shortly after the founding, and with that elaborate set of materials, the majority concluded that by agreeing to the Constitution itself, the states had agreed to allow themselves to be sued in bankruptcy. That is, the community college could be sued in federal court. Now, my minute has expired, but let me just note that for those who love the issues of, is original intent a method that is used by justices other than one or two, I commend to you the majority opinion by Justice Stevens and then the dissenting opinion by Justice Thomas, because they all agree on the interpretive methodology. They're seeking to understand the original intent of the framers. And so it raises the question, do they do it only at times but not at others? Perhaps original intent is very important when the issue is bankruptcy. Thank you for your attention.
Who knew that it was the Army Corps of Engineers with a blank check? We have a question from Jenna Holland.
You didn't mention the Anna Nicole Smith case.
Nor do I plan to.
That was a gift to the reporters. We deal with so many bankruptcy cases when we get one like that.
Right.
Just looking ahead to next term, the punitive damage case seems to be getting a lot of attention. Any predictions?
I'm going to not eat. I love Irwin's charming, he or she who lives by the crystal ball ends up eating shards of glass. But I do think that it raises some very basic questions jurisprudentially for the two new members of the court. The business community, of course, cares deeply about this, and the plaintiff's bar cares very deeply about this. What should be the judicially imposed, if any, limits on punitive damages? And here, Justices Scalia and Thomas have said it is not the role of the courts under the guise of substantive due process to, in fact, police jury verdicts. If states want to engage in that sort of, quote, reformation of the laws, that's the business of the states, but it's no business of the federal government, of the federal judiciary, perhaps even of the federal government itself. And I'm sorry we didn't have a chance to talk about the Commerce Clause. So I think it's up for grabs. Will Chief Justice Roberts follow what one might think are his instincts of minimalism, that the courts really should stay out of these kinds of controversies and just allow them to be worked through at the states level? Or will he, like Justice Stevens, who tends to have a rather robust view of substantive due process, say, I'm very happy for the courts to play a policing role and to say, as Justice Kennedy seems to be willing to say, this really does boil down to numbers and ratios. I think it's very much up for grabs.
Professor McGoldrick?
In the Rapanis case, which is a fascinating case, both because of the suggestions of the renewal of dual federalism and other kinds of issues, why is it that 4 justices couldn't agree with the significant nexus test of Justice Kennedy? It seems like 4 of them could have been brought along on either side.
Professor McGoldrick, you were brilliant, and you're way above my pay grade as to why it is that, that Justice Kennedy was not more influential. We know the process. The first thing that happens in the dynamic of the court is that the majority opinion is circulated, or the proposed majority opinion. So Justice Scalia clearly had the assignment. Again, there's a certain inference that I'm drawing, but he had the first shot. He then takes that first shot and has that very deeply textualist approach that alarms Justice Kennedy because of what he was concerned with, namely the West. Riverbeds dry up and so forth, and the approach of the plurality was very much to emphasize the idea of permanency of the water presence as opposed to episodically and the like. And so it may be that we have a very aggressive textualist, let's limit federal power, that just caused Justice Kennedy to say, you know, I need to find a new way, because I do not believe, and I haven't gone back to the briefs, that significant nexus was being argued by any of the parties. So I think Justice Kennedy was being quite creative, perhaps even clever, in coming up with what he thought was appropriate middle ground, rejecting the court can do anything that it wants, which really was, again, the issue that the dissenters really said, you know, they can just do what they want to, even though John Rapanis' land is 11 miles away from navigable water. That strikes many people as being, gosh, that's a long way for the Corps of Engineers, which regulated the waters of the United States. But they're ecosystems. We understand science and so forth, and I think that's where Kennedy felt that perhaps he was doing a great service in saying, what can we do under this? And it has a nice legal standard sound to it, doesn't it? Because it's obviously impressed Professor McGoldrick, and that impresses me, that it impresses you.
Thank you. Thank you, Dean, and Professor McGoldrick, and Jenna. We are not done, because we have a treat for all of you who have waited this long. We have 3 wonderful journalists who are going to give us some perspectives on the confirmation process. And to lead into that, we have several excerpts from Senator Kennedy and Senator Feinstein.
Supreme Court nominations are an occasion to pause and reflect on the values that make our nation strong, just, and fair. And we must determine whether a nominee has a demonstrated commitment to those basic values. Will a nominee embrace and uphold the essential meaning of the 4 words inscribed above the entrance of the Supreme Court building? Equal justice under law. Justice Lewis Powell spoke for all of us when he said, equal justice under law is perhaps the most inspiring idea of our society. It is one of the ends for which our entire legal system exists.
Senator Feinstein is coming.
It passed this Congress with overwhelming bipartisan support. The law was supported by an extensive
Senator Feinstein
factual
looks a lot
record,
like Mike DeWine.
and it was based on our government's long-standing constitutional power to fight discrimination wherever it exists. When the court considered the
No disrespect
whether your
to the
legal
candidate in
reason
Ohio.
is within the mainstream of American legal thought, and whether you're going to follow the law regardless of your personal views about the law. And since you have provided personal and legal opinions in the past, I very much hope that you will be straightforward with us. Share your thinking and share your legal reasoning.
As I've checked the record, you would be the first person.
Good enough. Senator Feinstein, in her comments, and a little bit less than Senator Kennedy's, has articulated a common complaint about the confirmation process. Namely that, as I whimsically said in the overview, questions were asked, very few answers were given. Now, the explanation, of course, is that both of the gentlemen testifying were sitting judges, that they were under the code of judicial ethics that precluded them from prejudging cases. Senator Kennedy this summer in the Washington Post penned an essay to the effect that that's just insufficient going into the future. He knows these people have thought about these issues. There's some evidence of that, and he wants to know what their current thinking is, and unless he hears that thinking, he doesn't intend to confirm anyone else. So, David Savage, with that as the lead-in, tell us your thoughts about the sufficiency of the confirmation process. Please. Please welcome David Savage of the law firm.
Thank you. It's good to be here. In an earlier life, I was an education writer in Los Angeles, and I used to have an occasion to come out here to Pepperdine to talk to classes in January or April or October, and I was convinced it was always good to be here. It was always pleasant. I also liked seeing Ken Starr and Doug Kamek again. I knew them from the Reagan administration days, Judge Starr and Solicitor General Starr, and of course Doug Kamek. Because I really think that with the arrival of John Roberts and Sam Alito, we're now into the second generation of the Reagan court. John Roberts and Sam Alito were some of the bright young conservatives who were drawn to the Reagan administration in the early 1980s. President Reagan, had a very strong view that judges had overstepped their authority. They were making too many decisions that should be left to the voters in a democratic society. And they were doing things like throwing out school prayers or overturning at one time the death penalty and throwing out the abortion laws that the American public didn't support, that in a democratic society, judges shouldn't be making those decisions. And I also thought the Reagan Justice Department had a series of very distinctive, clear views about the law. They were skeptical of affirmative action and any sort of use of race by the government. They tended not to believe in the strict separation of church and state. They thought that was an incorrect interpretation of the First Amendment, that there should be more room for religion. They thought Roe versus Wade, of course, was wrong. They were less enthused by environmental protection and more supportive of property rights. They tended to believe what I think Doug Kamek would phrase sort of robust executive power, not meddling by Congress, and sort of a preference for states' rights over federal power. Now, my sense is that John Roberts and Sam Alito share all those big views, and we'll see that in the years ahead. I also share the view, a number of people have mentioned, that I thought the most interesting words that were said at the John Roberts confirmation hearings were his comments in that very fine opening statement about judges as umpires, that I want to call the balls and strikes. I don't want to make the rules. I don't want to be the star of the game. I thought there's a very clear way of sort of saying what Reagan believed, which is that a judge shouldn't have such an important role. I must say, to be honest about it, I heard it with sort of mixed feelings, because something personal and a sort of a conflict of interest on my part. I don't know whether Jenna and Marcia share this, but if you're a full-time reporter whose job is to cover the Supreme Court, it's not altogether good news when the Chief Justice said, I want a more modest institution, a humble institution, an institution that doesn't make waves. It sort of conjures up visions of the do-nothing Supreme Court. And, you know, newspapers don't assign reporters to cover the Federal Home Loan Bank Board. Or to state it another way, in the John Roberts view, is when's the last time you picked up the sports page and read a profile of an umpire? But something tells me that the court will sort of rise to the occasion, continue to take on big legal issues, and make and there's so many big legal issues that come to the court. It's going to continue to, I think, to be a very interesting place to watch for a number of years. We were supposed to be talking about John Roberts and the rookie year. I would say one thing sort of in the baseball context. When this guy takes the field, you'd say, this guy was born to play the game. I mean, he is a real natural talent. And John Roberts strikes me as one of these people who is a very happy situation of somebody who rises to the top based on merit. In the 25 years he was in Washington, he was never a person who sort of tooted his own horn. He was never the kind of person who sort of went out of his way to call attention to himself, which I suppose you could say in Washington that makes you unusual in that sense. But I thought the interesting words were the notion of modesty, humility, no dramatic departures. And I thought at this term, in the cases we've talked about, there were signs that point different ways. I am more impressed, I think, than Irwin was with a number of the unanimous decisions. I thought Roberts did a remarkable job of sort of finding a smart middle position on a lot of big cases. Had we been here a year ago, we would have been talking about Ayotte, the New Hampshire abortion case. And there were two sort of polar opposite positions presented to the court. The ACLU said this parental notification law is totally unconstitutional and it can't go into effect because there's no, quote, health exception. Well, the New Hampshire legislators didn't want to put a health exception in because ever since Harry Blackmun's opinion in Roe versus Wade, health, he said, means anything that the doctor thinks it means, including the emotional well-being of the patient. Well, the New Hampshire legislators knew if we put a health exception in, it sort of swallows the rule. A doctor can violate the law. New Hampshire's position was, our law is fine. What's the big deal? If you've got a problem, go to a judge, have a hearing. Well, that's not a very good view either. I mean, if you have a young woman who's bleeding, you don't want to go and take her and go to a judicial hearing. You want to go to the hospital. And so from the very beginning of that argument, John Roberts sort of took the position that both views were wrong. They were too extreme. And he ended up finding a unanimous opinion that basically said, yes, this law can be constitutional, but there needs to be some exception for real medical emergencies. I thought that was there was a half dozen situations where I thought the court, with Roberts taking the lead, came out with a very reasonable middle ground position. There were at least two, I think, that point the other way. We were just talking about the wetlands case. Clean Water Act of 1972 basically said, it's illegal to discharge pollutants into the waters of the United States. And for 30 years since then, the Army Corps has taken in federal regulations this very broad view of the law, because the notion is you can't protect the Santa Monica Bay from pollution if people up here in the mountains can put pollution into the streams, it'll flow into the bays. They took this very broad view. Republican administrations, Democratic administrations, Republican-led Congresses, Democratic-led Congresses. It seems to me the modest view would be to say, if this law is being overinterpreted, why not let Congress write a new law? Had John Roberts had a majority with Justice Scalia, remember Justice Scalia's position makes a lot of sense based on the wording of the law. He said the Corps only has jurisdiction over continuous flowing bodies of water. And as Ken mentioned, Justice Kennedy, well, that would eliminate all the wetlands in the West because they're dry at this time of the year. And so I think had the court had a 5-member position to take the view that John Roberts took and Justice Scalia did, that would have been a dramatic departure. And the other one, it was the Oregon case. 1994, the voters of Oregon passed the Death with Dignity Act. They don't like to call it assisted suicide, I've learned, because they make the very interesting point that when someone commits suicide, they are saying, I want to die, I choose to die. These people don't want to die, they are dying. These are people who are terminally ill, and the only question is, are they going to die this week or 4 weeks from now? And they said, if the doctors certify that this person is terminally ill, you can obtain lethal medication from your doctor and take it on your own. And I've talked to a lot of these people. You know, that there's all kinds of reasons. Some people are in pain. A lot of people are in pain of their families having to take care of them for the last couple of weeks. In 1997, the Supreme Court said there's no constitutional right to die. We're not going to make the same mistake we made in Roe versus Wade of sort of deciding this nationally. We're going to leave it to the states. Okay? Some members of Congress, including John Ashcroft, asked Janet Reno to put out some order that would basically void the Oregon law. Why not just say under the federal drug control laws, these doctors are violating the federal law? And Reno said, no, the federal drug control law was about narcotics. It didn't give me, as the Attorney General, the power to prescribe the practice of medicine. That's left to the states. That's the way things stood. In November of 2001, now Attorney General John Ashcroft put out a new order that basically said what he wanted to do when he was in Congress and couldn't get a majority to do it. That is, he said, Oregon's doctors are violating the Federal Drug Control Act if they prescribe this medication. It's not a legitimate medical purpose. The Oregon doctors went to federal court. The law was enjoined. The Ninth Circuit affirmed that. It came up to the Supreme Court in the first week that John Roberts, the first week or second week in October last year. It ended up as a 6-3 decision affirming the Ninth Circuit, upholding the Oregon law. But Roberts, the Chief Justice, joined Justice Scalia and Thomas in dissent in saying, basically upholding the Ashcroft view. Now that too does not strike me, had there been a majority for that, that would not have been a particularly modest act. It would have been overturning the wishes of Oregon's voters and upholding a new interpretation of an old federal law that Congress had never endorsed. And so I think that too could be, had there been a majority for it, grant you he was in dissent, that would have been quite a dramatic departure. So I think it's going to be very interesting to watch over the next few years to see whether the Roberts Court is a really sort of modest, down-the-middle court, or it becomes a much more aggressive court of sort of pushing in different ways that sort of reflect the strong views back from the Reagan era. I'll say one other thing. I always think learned talks need some statistics. Mine are 86, 73, 58, 56, and 51. Now, that's not like the joke about the old New York teacher's exam. You know, there'd be a series of numbers that were unrelated, and they were the stops on the 8th Avenue subway. Only a New Yorker would know them. These are the two oldest members of the Supreme Court, are the two most liberal justices, Justice Stevens and Ginsburg, and 3 of the 4 strong conservatives. Justice Thomas is 58, Sam Alito is 56, and John Roberts is 51. So the second generation of the Reagan court is alive and well and is going to be with us for a long time, and it's going to be fun to watch. Thank you.
In light of the time and the fact that I want to hear from both Marcia Coyle and Jenna Holland, I'm going to save any questions for this panel until the end. So please welcome Marcia Coyle.
As you can see, David is fascinated by the confirmation process.
I wasn't going to point that out.
It's a common reaction by those of us who had to sit through 2 of them in 4 months, gavel to gavel. But I did take Professor Kmeck's memo to me to heart. He asked me to talk about the senator's questions and media coverage. Now, I'd really like to say that when I got that memo, I immediately came up with at least 10 tremendous insights. But what really came to mind was this contest that I saw on a blog right before the Roberts hearing, asking for submissions of the dumbest thing said or dumbest question by a senator. The blog was overwhelmed by the end of the Roberts hearing. And I'm sure you want to know what at least one of the winners was, who it was. And I'm going to be charitable and not reveal his identity. But what the heck? You've been here all afternoon, right? So I'll share it with you. It was Senator Tom Coburn of Oklahoma who said to Roberts, "I am using my observational capabilities as a physician to know that your answers have been honest and forthright as I watch the rest of your body respond to the stress that you're under." Okay, it's easy to poke fun, I know. But seriously, I think few of us leave the confirmation hearings feeling fully satisfied by the questions that were asked. The senators today play predictable roles. The party of the president who nominated the justice is there to protect and defend, and the opposite party is there to try to reveal as much information as possible. There have been lots of books written about the shortcomings of the confirmation process, and I really would suggest you read some of those, like Stephen Carter's The Confirmation Mess. There's a brand new one out by Benjamin Wittes that Professor Kmeck mentioned. I think it's coming out officially in September, published by Rowman and Littlefield. All great. I'm just going to make a few quick observations about the questions. One problem is there are so many. I saw some statistic that stuck in my head about Justice Alito, what he faced. 18 hours and 700 questions. Second problem, very little follow-up on the answers that are given. An example, when Justice Roberts did say that he recognized a right to privacy, there was no follow-up to ask where would he go with that in terms of substantive due process. It was the same with Justice Alito. He was questioned about the unitary executive theory, and that's very controversial, but there was no follow-up after he gave his response to ask him, well, how do you square that with the constitutionality of independent agencies? So I think follow-up is a problem. And why is that? I think that it appears there's very little coordination. They may try to coordinate, but it seems as though the senators come in, they've got their questions, they want to get through them, they have interests that they want covered, and then that's it. I also found what was very interesting is what wasn't asked this time around. There were virtually no questions about sentencing, plea bargaining, very little on First Amendment speech, church-state separation, really very little on affirmative action, death penalty, and Kelo, which was such a hot decision by the Supreme Court on property rights. But what the questions do reflect, I think, are what the senators are most concerned about or what they think their constituency is. We had a lot of questions about executive power this time around. They were very worried about the surveillance program, the military commissions. At the end of the day, it's really left to the media to find a way to present the hours and hours of information gleaned in an organized and coherent way for our readers, our listeners, and our viewers. I'm not a media critic, and I don't want to be one. I'm not going to say, well, the New York Times did this, and the LA Times did that, and they should have done this. I think overall today the media does an excellent job of getting all the relevant information, and maybe not so relevant, out to the public, and perhaps not so excellent a job of presenting it in a way that gives your audience a clear view of what the information means. And part of it is just the sheer amount of information. I mentioned earlier the blog example. And I did it humorously, but I do want to tell you that I think probably in terms of news and information, what was really defining about this confirmation process is that Roberts and Alito truly were the first Supreme Court nominees of the internet age. All of us in the media today are dealing with increased pressure to get information onto our websites, and even some reporters now are being asked by editors to blog off their beats. And so there's this incredible pressure to compete with the immediacy of news. The blogs, to me, were the most fascinating aspect of this whole internet feature of the confirmation hearings. I started reading them very closely during the confirmation hearings, both political and legal blogs, and I was amazed at the amount of information they generate. And it's not just gossip and rumor. A lot of them presented detailed background information on all of the nominees, opinions, links to cases, reports. Some had highly placed sources. I don't consider them established news media, but I do consider them, I think in the future, to play a very significant role, perhaps akin to what television did to the confirmation hearings. People look at the confirmation hearings and they think, oh, they've become a mess in the modern age. But if you read some of the books that have been written, you'll see that confirmation hearings have been a mess for a long time, perhaps going all the way back to Justice Brandeis. And one book I saw found 3 factors to contribute to the way they were, the way they are now. One, and why they're seem so political, so disorganized. One reason is political parties for a long time, until the 60s, were mainly grassroots parties. But beginning in the 60s, we had the rise of national political parties that were policy-driven. Another factor was the role of the Supreme Court itself. It started deciding individual rights cases that were very controversial. So this made the court more of a factor, more of interest to the public. And finally, television. Putting the cameras in the confirmation hearings and even on the Senate floor changed the nature of it. The senators are playing a lot to their constituencies. Now, I support television in those hearings and on the floor. But what I'm saying is I think blogs, podcasts, all of this is also going to have a major role down the road in how nominees present themselves and how senators question them. I know in one blog site, and this was not uncommon, that people would post opinions maybe 5, 6, 10 times a day, and those postings would attract anywhere from 200 to 500 public comments. Special interest groups all had their own blogs. They had podcasts during the confirmation hearings. This is all part of trying to convey a message to the public, trying to influence as well the media. I know that White House officials talk to bloggers in order to get their message out about the nominees. And so I think what we saw with Roberts and Alito is only the very beginning of what will be quite fascinating down the road as we head more and more into the internet age. And I'm not sure what the ultimate impact is going to be. There are those who've written books who've suggested that we eliminate confirmation hearings and go back to private meetings. There are those who suggest that perhaps the Senate Judiciary Committee ought to have designated hitters, one from one party, one from the other, and just have legal counsel doing the questioning in order to make it more manageable. But I don't think we're going to be able to retreat from the very, very public aspect of confirmation hearings today. I think the public wants to see these nominees, and I think because of the immediacy of the internet, they're going to want to know as much information as they can, or answers to the questions they have, as soon as possible. So it'll be very interesting to see how it plays out.
Thank you. Marcia has been writing for a good many years for the National Law Journal, and her commentary there is excellent, but you can also see in her comments why the NewsHour has made her the regular Supreme Court commentator. She deals with cases and legal issues with intelligence and with conciseness, so we thank you for that. It is interesting that her prediction that the nominees will not soon be excluded from the process is directly opposite from the 1988 report of the 20th Century Fund, which wrote up a report following the Bork episode, in which they made the following 4 recommendations: limit the number of participants in confirmation hearings, prevent nominees from testifying, prevent senators from asking nominees questions about how they would deal with specific issues, and base confirmation decisions solely upon a nominee's written records and testimony from legal experts. There was an old folk song that I like by Steve Goodman called "The 20th Century is Almost Over." I think it's over. Jenna Holland.
I've been watching the clock thinking, fabulous. I can talk for 2 minutes and send you home. I think the confirmation hearings left us wanting, and maybe the public as well, more information on substance-wise, but we got a little bit of the style of the justices. And the 2 men you saw on the screen are very much on the bench like they were before the senators. John Roberts, particularly, was very comfortable before the grilling of the senators. And on the bench, he is also just right at home. He's funny, not as funny as Scalia, who is. David was talking a little bit of the surprises or what we expected. He does ask a ton of questions on the bench. And that, I guess I was surprised. I mean, during the confirmation hearings, he talked a little bit about Rehnquist and would he be a Rehnquist-type Chief Justice, and that he wanted to be his own man. And he, unlike Rehnquist, who asked very few questions and was really concerned just with more the keeping of the time, and if one of the justices ran on too long, he'd rap them, not literally, but say, let's move on, grumpily. Roberts is a very active questioner, and to use his words, I think he strategically will lay traps and very smart ones in cases for that lawyers we've seen get caught in them. He was a very good litigator before the court, and he's turned that around on the other side. And I feel sorry for some of the lawyers. Erwin, you survived, sort of, except for that. Sorry, the 8-0. But
Do you want to talk about the 10 Commandments?
Versus now, I lost 8.
But just quickly touching on Alito, he appeared a little uncomfortable before the Senate, and on the bench so far has not quite hit his stride. He asks very few questions, sometimes an argument, sometimes none. And I read a recent interview that he gave, and he indicated he was having trouble with the microphone button. Maybe it was something like Jeopardy, where you have to hit the button first. And so hopefully, Alito of the future will jump right out there and get a little faster. But the thing I do like about Justice Alito is that he does seem pretty human. With John Roberts, it's almost absolutely perfect. Every article you read for the longest time said charming and likable. And with Alito, maybe there's a sympathy factor that he had to follow Roberts. But I like that he maybe doesn't necessarily say the right thing every time and doesn't know every rule. He has had a few blunders, but we're not all the cool kid in the class. And so I look forward in future years seeing the two of them.
Thank you, Jenna. I see a hot question from the audience in Bernard James's hand.
Well, it's a contestant for the most ridiculous question asked by a Senate Judiciary Committee member. Has there ever been a confirmation hearing comment to rival Nebraska Senators Roman Ruska's comment regarding nominee G. Harold Coswell? A mediocre lawyer and with a mediocre judicial record. The comment is, and I quote, "There are a lot of mediocre people in this country, and they deserve representation on the Supreme Court, too." Marcia, I think you have number one.
What was the question?
I'm not sure there was a question.
Well, and that's a good note to end on, but we do have an opportunity to thank the wonderful people that have joined us today, and I would personally like to thank each of the journalists and each of these splendid scholars, as well as my colleagues, and allow Dean Starr to give the official concluding thought.
Thank you for joining us. Please join me before adjourning in saying, and welcome to the reception in the atrium, how grateful we are to our wonderful panelists and to our dear Doug Kmet.